Hi, y'all, and welcome to tonight's live stream. Have we just found hen's teeth? Is it a blue moon? Has hell frozen over? Because at today's hearing in the Karen Read case, Judge Cannone ruled with Karen Read on a huge motion. Now, many people have contacted me about whether or not I believe Judge Cannone has been fair to Karen Read. People have asked in the chat. People have called me. People have texted me. There have been lots and lots of questions about whether or not Judge Cannone has been fair. And I've said, I feel like she has kind of the normal amount of bias that most judges have toward the prosecution, and maybe a little bit more, but I didn't feel like she would never rule for Karen Read. Well, today we got some proof of that. And honestly, it's not the first time she's ruled for Karen Read. But today it was a very critical motion, as was the one about whether Karen Read's attorneys would be barred. In my opinion, Judge Cannone did not have to rule with the defense in this. It wasn't that the law was so clear she absolutely had to do this, but she did that. She ruled with the defense. So we are going to get into it. We are going to talk about whether or not Judge Cannone ruled correctly. We're going to be talking about what the motions were. There were two huge motions today. Judge Cannone ruled on one for Karen Read, but she still hasn't ruled on the other one. So in fact, on that first one where she ruled, she absolutely shut it down. I think her critics are going to have a much harder time lambasting her from now on, because I think it was definitely a ruling that was pro the defense today. But as I said, there's a second critically important motion. We don't know how she's going to rule on that one yet. We're going to cover both tonight. So let me go back and check who the first five in the chat were so I can say hi to them. Just a Girl, Sycamore Sally, Loretta Powell, Desert Rose, and Fiverr. Thank you all for that. I appreciate you being in the chat early. All right, so let's take a look at what happened today at the hearing in the Karen Read case. Now, Karen Read is accused of backing her car into her boyfriend, Boston police officer John O'Keefe, and leaving him to die in the snow. She was dropping him off at a party at Brian Albert's house. Now, she says she dropped him off. He went on into the house where somebody in there did him harm, then left him in the front yard to die. Now, she was tried once, and the jury could not decide, and the judge declared a mistrial. Now, there's a lot more to that story, but we're not going to get into that story tonight. Right now, Karen Read is rocketing toward a second trial with jury selection starting next week. For this retrial, the Commonwealth has brought in a brand new lawyer, Hank Brennan, and it's clear that he is trying at least to do absolutely everything differently to make this trial as different from the prior one as he conceivably can. He's filed many motions. Today, the court heard two. And both of them have the capacity to radically alter that second trial that's coming up. Now, motion number one, she denied. It really is pretty funny how it happened. So I'll take you through that, and you can kind of get a chuckle with me too. But to understand it, I really think we're better off starting with the document that got filed in terms of understanding it. I need to say thank you to Bethany, too, who has gifted 10 lawyerly memberships. Thank you. I really appreciate that, Bethany. We are having a marvelous time, by the way, members. We're writing our very own true crime novel. It's a blast. We have our next meeting. We're going to be having a meeting of the mid-tier and higher tier members. We're going to be introducing some really something new, something different. And then we're going to be meeting again with all the members right after that. So that's all yet to come. All right, so let's take a look at the motion that Hank Brennan filed on behalf of the Commonwealth. The prosecution in Massachusetts is called the Commonwealth. And you can see right from the beginning, it is something very, very unusual. I'll make it a little bit bigger so people can see better. I'm going to rearrange that. Okay. It's called the Commonwealth Motion to Compel Communications between the defendant and attorney Yanetti stored within the defendant's cell phone data. Already, that's something wildly different, because normally there is an absolute protection over attorney-client conversations, communications. That is something that is closely guarded. You're going to hear the defense talk about how important it is to guard that. But the Commonwealth is saying, we want to actually get the communications between Karen Read and her lawyer for about a 5-day period. They call it a 3-day period. You'll see what I mean. And that's coming from her cell phone data. The way it worked was the cell phone was confiscated, taken by the police, and they've gone through it and they segregated. They had a different lawyer go through and say, okay, here are communications with counsel. No one else can see those. They put them in a separate pile. And then they handed to the defense, and yeah, it was probably electronic, handed to the Commonwealth. I mean, all of the ones that they were allowed to see, and then kept back the ones that were between Karen and her attorney because those were privileged. So that's what so far has happened. Right now, the Commonwealth, the lawyers actually trying the case, have never seen the communications between Karen Read and her lawyer. They use something called taint counsel to protect from the Commonwealth accidentally seeing some of those communications. That's how important it is that those not normally be disclosed. So here's what the Commonwealth wants. The Commonwealth seeks all texts, emails, or written communications between the defendant, Karen Read, and attorney David Yanetti, restricted to those communications that occurred between January 29th, 2022 and February 2nd, 2022. Karen Read has waived her attorney-client privilege with attorney Yanetti relative to any statements about her collision with John O'Keefe during the time of January 29th, 2022 through February 2nd, 2022. See how narrowly tailored that is. The defendant voluntarily and intentionally disclosed the existence of those communications and her initial thoughts about her culpability for causing the death of John O'Keefe during various public interviews. So what the Commonwealth is saying here is that the attorney-client privilege has some limitations. One is you have to actually keep your communications confidential. If you go out and tell everybody what you said to your lawyer, what your lawyer said to you, well, at that point, they're no longer privileged. You have waived your privilege. And so the Commonwealth is saying that's exactly what happened in this case. Karen Read went out, she talked to the media, and she told them about what David Yanetti told her, about what she told him. We're entitled to see that now because she's waived that. She has kissed it goodbye by what she did. So let's take a look at what exactly let me talk for just a minute about what exactly Karen Read did so we have kind of an understanding of that. Even the media called it unprecedented because Karen Read actually went out and did interviews with the media. There was even a docuseries that has been released now that related to all her preparations, and we're getting ready for trial number 1. Now we're about to hit trial number 2, and all of this information has come out into the public. Now, I've talked in the past about how much, I'll go ahead and pull this out so I can talk to you. I have talked about how much the landscape is, I should check over here too. Let me make sure no one is saying that I've been muted like last night. Okay, that the landscape is really changing for lawyers and for the legal field because of social media. And it's not something that lawyers have dealt with in the past. And frankly, we're getting it wrong a lot of the time. Lawyers and courts have traditionally thought that you can file a case about a notorious crime, you can slam the lid on that and basically keep it all under wraps until trial. But that is crumbling now in the face of social media. Now the prosecutor comes out, does a big press conference, the media covers that, and more importantly, social media covers that, gets hold of it. Of all that information so far is just related to the prosecution side. So whatever was released, like the arrest warrant affidavit or indictment, whatever it was that was made available to the public, that's pretty much all that anybody has. And what the defense has done up until now is pretty much said, Well, that's it. We'll fully agree that everything should be kept under wraps so the jury is never tainted. They aren't hearing anything about what's going on. Then what happens is social media runs with what's available. And the only thing that's available is the prosecution side. And people try to fill that in, not always correctly, because they're dealing with lack of information. So Karen Reed's case is extremely educational for this reason, because she has harnessed social media in a way that very few people have. But it comes at a price, at a potential serious cost, because it comes wrapped in the danger of pushing too hard. Today, we're going to see a place where she went right up to, and in my view, over that edge. So let's take a look at the rest of this motion. Let me add it back to the screen. Okay, so we're now going to be taking a look at what the Massachusetts rule is. It's cited by the Commonwealth in its brief, Massachusetts Rule of Evidence 523. And it talks about when somebody waives the privilege. A privilege is waived if the person, that'd be Karen Reed, voluntarily discloses or consents to disclosure of any significant part of the privileged matter. So notice it has to be voluntary. Nobody has forced her to do it. She voluntarily did that. And she consented to it, to disclose it, and it has to be a significant part of it. Now, next, there are a couple of exceptions. This is conduct, things you could do that would not amount to waiver. And it does not waive the privilege if the person merely testifies as to events which were a topic of a privileged communication. So if, in other words, Karen, let's just say it's a car wreck, and the person comes into court and says, yes, I was coming up to the red light, it was red, and I stopped, and the other person across the way, they didn't stop, and they plowed right into me, whatever they say. So at that point, the fact that the person has also talked about that with their lawyer, that isn't waived by the fact that they just testified at trial. That's something that's separate and different from that. And number two, there is an unintentional disclosure of a privileged communication, and reasonable precautions were taken to prevent it. That won't really apply here because Karen Reed actively and intentionally went out to talk to the media. That's what the Commonwealth is bothered about. And let's take a look at what she said that the Commonwealth is pointing out specifically here. Recorded interview with Gretchen Voss. Question, you never said, did I hit him? I hit him. And let me talk for just a minute about what that's about, because a number of people who were present at the scene when Karen Reed and her two friends who were with her found John O'Keefe lying in the snow outside Brian Albert's home. They called 911, and several people at the last trial testified that Karen Reed said, I hit him, I hit him, I hit him. And so that became one of the Commonwealth's critical points. They said she was admitting to us, to all of us, that she was the one who hit him. She knew that, she admitted it. So the question from the interviewer to Karen Reed was, you never said, did I hit him? I hit him. And the answer from Karen Reed was, I said, did I hit him? Which is different. And then, when I talked to David Yanetti, her attorney, now this is later, David said, Karen, if you incapacitated him in any way, there's capability there. I think they mean culpability there, guilt, in other words. And I thought, all right, maybe this is maybe. I said to my mother, just to go forward a second, they were asking me, what was it like? Did they come out? What was the house like? And then the Commonwealth adds Attorney Yanetti, Attorney Jackson, and Attorney Little, all three of her attorneys at the time, she's now added a fourth, were in attendance along with the defendant and Miss Voss. Miss Voss being the interviewer. So this is super confusing. I think it's not really clear what exactly she's saying, except that she does say that her attorney told her, look, if you hit him, if you incapacitated him in any way, there's culpability there. You could be found guilty. And there could be guilt there because of the fact you hit him. But it's not really clear. It is clear that she talked to her attorney about it, and let's keep going. We'll hear a couple more. She told Vanity Fair that she volunteered that there was a rumor that alleged representations made by the Massachusetts State Police that there is a text message between Karen Read and counsel that implicates Karen Read is a provable lie. She used the words provable lie. And I think that the Commonwealth is trying to say, look, if you tell people you can prove something, you need to ante up. You need to show us what you actually have in the way of proof. I don't think this one is as important, because what she's saying here is just that this rumor that I wrote this text message implicating myself, I can prove that that's false. Now, I'm guessing that the Commonwealth believes there is exactly such a text message inside the communications with Yanetti, but it's not really clear that that it's there. It was just a rumor. I don't really see that as a particularly strong one. But let's get to one that bolsters the first one we talked about. This is from that 5-part docuseries on investigation discovery in HBO Max. And here's what Karen Read said. And then when I hired David Yanetti, her lawyer, I asked him those questions the night of January 29th. Remember, the last one said it was later, so the timing was a little bit more questionable. But tonight, the night of January 29th, like, David, what if, I don't know, what if I ran his foot over, or what if I clipped him in the knee and he passed out, and or went to care for himself and he threw up or passed out? And David said, yeah, then you have some element of culpability. So that's how I thought about things for about 3 days. So and you can see where that would be extremely damaging in front of a jury, because there's no reason for her to ask that of her attorney, but she's voluntarily saying, I asked my attorney, what if, just asking, what if I clipped him on the knee? What if I ran over his foot? Something like that. Now, I am positive that Karen Read would say, I was just worried about it because I didn't remember anything like that. I am sure she would say that. And that the fact that she says that's how I thought about things for about 3 days suggests she changed her mind after that. But there is another twist on this if you're the Commonwealth. And that's the idea that she pretty much said to her attorney, look, let's just say I ran over his foot, I clipped him in the knee. Let's just, like, what would that mean? And her attorney was like, yep, you would have an element of culpability. You could be found guilty. That is critically important because it's her attorney making a statement about her guilt. Just imagine that coming in front of the jury. It could be really, really damaging. Now, they also argued in this brief that in addition to rendering the communications non-privileged, as you see down here, the communications are relevant as admissions and statements of the defendant. And we'll pull out. So what I think they're arguing there is not something that I believe the court ruled on today. They're saying, look, these are admissions by her, and that would be true of the things she said to HBO or the things she said in Vanity Fair or to Gretchen Voss. Those things could be considered admissions. I don't think the judge has ruled those out. So I do believe she will still face an actual they will actually play or talk about some of those interviews. I think that is still to come. That argument has not been decided. The judge has not ruled those out. In other words, what she ruled out with her ruling today was actually seeing the communications between David Yanetti and Karen Read. She's basically saying what you got is already enough. And I'm not going to let you see the actual text messages or communications between those two. So I want to show you kind of what happened at the hearing. And part of this is really pretty funny, I think. I am a little nerdy, so you'll have to come along with me on that. But I do think it's a lot of fun. Bethany has gifted another 5 Lawyer League memberships. Thank you so much, Bethany. I really do appreciate that. We have a happy birthday going out to Matthew Sullivan. Thank you, Mama Pinks, for letting us know. And happy birthday, Matthew. We are glad to have you with us tonight on your birthday. All right. And Katie W., thanking me for the extra live. It was a really interesting hearing. We're going to get to see right now.
And that's a 3-day period. And that is what is mentioned by Ms. Read in her public statements, that she spoke to Mr. Yanetti and she thought about it for 3 days. We're not looking for any information beyond what has been waived. We're not looking for any information on collateral issues, and that's why we suggest that the court look at those records in camera, and the court makes the assessment whether or not the area in which where Ms. Reed waived her attorney-client privilege, whether any of those materials would similarly be waived because they are exactly related.
So what he's doing is telling her, Judge, we're not asking for everything that David Yanetti ever said to Karen Reed or every text message she ever sent to him. We're only asking for ones related to what she had to say about the potential collision, about this culpability issue. We're only asking for that, and we're only asking for 5 days. And he explains, that's not privileged anymore. He believes it's not, and why he doesn't think it's confidential anymore.
Anything that is non-privileged is open to the public. It's not confidential. These statements were made during conversations that are obviously no longer protected or private or privileged. They're no longer confidential because they've been intentionally disseminated to the public. And so the defendant has voluntarily waived that privilege as to these communications in this subject area in that time period. And the key, Your Honor, is that it is the defendant herself who made the communications confidential. There can be no doubt that there was an intention to pierce that attorney-client privilege for whatever benefit the defense thought it gained them. This was intentional. It wasn't secretive. It wasn't overheard. It was a exacting and purposeful engagement.
So let me talk for just a minute about why it is that I think the Commonwealth could be considered right in this case, why I think the judge could have ruled with the Commonwealth if she had wanted to. There's a saying that let me talk even more fundamentally about the attorney-client privilege. One of the bedrock rules is it's only between the attorney and the client. As soon as you put a third party in the room, you lose the privilege. There is, for example, a marital privilege. If your spouse is in there, usually in most states anyway, that would be a privilege. But let's say you put a friend in there, that's always a problem. Lawyers are always worried about that because the privilege is broken when someone else gets in the room. And when the someone else is the media, the Commonwealth is saying it's really, really broken. And there's a saying that you can't use the privilege as both a sword and a shield. And what that means is you can't use it to protect yourself and then you can't use it affirmatively, go out and say something and then try to protect yourself at the same time. You've got to choose which way it is. As a general principle, it means you can't take advantage of the privilege at the same time you're claiming it protects you. You have to decide between those two. And in this case, the way that could be interpreted would be you can't go out in public and talk about these conversations in a way that you hope will benefit you and get the public on your side, and then hide behind them by saying that everything you said was privileged. So Judge Cannone, I think, would have been within the law to rule that the communications had to be turned over, as limited the request was by the Commonwealth. But because Karen Reed had referred to specific conversations and specific things that were said, and she said this to a third party. She did it in an interview where she was basically trying to get out her statements into the public domain without testifying. She was trying to get the advantage of speaking publicly about communicating with the public. And that has been a huge advantage for her. But she was trying to do that without turning the communications over. So as the rule of evidence that we talked about earlier that was cited in that brief said, she voluntarily disclosed this. And I think it was a significant part of the privilege matter. So I think that the judge could have ruled with the Commonwealth if the judge really, really wanted to make it a statement like that, if the judge had wanted to. So, but what happened next was really pretty funny because there is a new attorney on the Karen Reed bench, Alessi, and he is sort of known for longer responses. He's very thorough, very lengthy. And so I saw one comment today where I was watching the hearing and somebody said, I'm going to need to get more than popcorn. Oh, it's Alessi. I'm going to need to get more than popcorn for this one because it could be a long time. And and let's just watch what happens. I think it's pretty funny. He starts out very thorough.
Throughout its motion, as it must, that the communications it seeks to intrude into are privileged communications between Ms. Reed and her attorney, Mr. Yanetti. 2 of the 3 instances of the communication they cite to are over 9 months old, and that's in 5 months old, respectively, to raise significant issues like privileged communications this close to trial. The Commonwealth does not explain.
Now, he, like I say, thorough. He is very thorough. Giving up an attorney-client privilege is bad. Every man, woman, and child should be upset.
The depth of this attempted intrusion by the Commonwealth should disturb and unsettle every citizen of this Commonwealth because they're either actual or potential clients of lawyers, and it should unsettle every criminal defense attorney in this Commonwealth, and I would dare to say it probably does. As we know, texts, emails, and written communications, exactly what the Commonwealth is seeking here, between an attorney and their client are canonical examples.
Okay, he even takes it back to Shakespeare, okay, and to an 1831 Massachusetts case. And I can laugh at this because I would do the exact same thing. I like to think I was fairly brief, but boy, was I thorough. When I researched something, I read everything on it. So I can really laugh at this because I really am like this.
Examples of privileged material. So what is at stake in this motion? What is at stake is the sacrosanct attorney-client privilege. In Upjohn versus United States, the really bedrock attorney-client case from the U.S. Supreme Court, it established that dating at least from the age of Shakespeare, the attorney-client privilege is the oldest of privilege for confidential communications known to the common law. And this Commonwealth has identified that it is one of the most important, and it's been recognized in the Commonwealth as early as 1831.
And he is just getting wound up. You'll see this last little bit, and then we'll get into what the judge does.
Here's a key point. In the interests of justice, and that's the rooting of the interest of justice analysis, to the right to counsel and to an effective attorney-client relationship. With that law jurisprudential predicate in mind, I now turn to the statements at issue here and their import to that analysis.
Okay. The judge absolutely cannot take it. She's like, no, we are not going to go to the statement of issues and their import to that analysis. We are not doing that. So she jumps right in. She already knows how she's going to rule. So she doesn't need all that. And she's, no, we are not doing another one.
You know what, Mr. Leslie, I'm going to stop you. I understand the Commonwealth's argument regarding waiver. I understand that the request is narrowly tailored. I'm not going to give you this information, Mr. Brennan. I don't even think it's appropriate for me to have, so the motion is denied.
The defense is stunned. Like, what? We won? And I let this in because watch Yanetti come over to Alessi. Oh, thanks, man. You did us a solid. Thank you. Well done.
Higgins
You
was
didn't
clearly
even have to
pining over-
argue. Okay, we're going to stop there. But I will tell you, I thought that was hilarious because she was like, okay, no, let's just stop there. She already knew what she was going to say. And I don't think that legally she had to do that. I think she could have ruled for the Commonwealth under the law if she had wanted to. And there, in fact, the Commonwealth still might have an appeal issue on this because I think there is a pretty good argument that she waived it. But it's always disfavored. That means the courts hate it. When you force somebody to turn over attorney-client privilege matters, that's obviously really dangerous. It's a bell that you can't really unring once those come out. it's really, you can't really put the genie back in the bottle. So this, it was much safer what she did. And I think it's an example of her ruling for Karen Read when she did not have to. And it was a huge win for the defense. That was the first of 2 motions today. The second one, we do not yet know how Judge Cannone is going to rule, but it was another huge and bombshell motion filed by the Commonwealth. And I'm going to tell you something pretty funny that Karen's attorney said about it. We're also going to watch just a minute. As you can see, we're going to watch just a tiny clip from Alan Jackson in closing argument so you can kind of understand what we're talking about. First, though, I want to say thank you to Jeremy Kelly for 20 lawyerly memberships. Thank you for gifting that. Be sure to turn on your ability to receive a gifted membership. Our mods will put in the chat how exactly you go about doing that. And then you can turn that on. YouTube randomly distributes these, so you have to have the ability to get that gifted. You can also, anytime you want, go down and hit the join button beside the name of the channel, Lawyer Lee, and join as a member. I appreciate it's just a way of financially supporting the channel, although we do have a really good time. Okay. So Regina Edwards has gifted 5 lawyerly memberships. Thank you, Regina. I appreciate that very much. And it's such a great thing when we bring people along who can join us as members. I love that, and I really appreciate your doing that. Big Apple Hoosier, love the intro. Thank you. I appreciate it. And Desert Rose is a new member. We have a happy 47th anniversary. Luann, that is awesome. Thank you, Mama Pinks, for letting us know. Happy 47th anniversary. Luann, that's awesome. Congratulations. That is really fantastic. Glad to have you along on your 47th anniversary. Okay, so let's talk about what and I should pull out. Let's talk about what this other motion is that we discussed today at the hearing. Think back to the first trial of Karen Read. One of the things that made it such a media sensation was the fact that bombshells just kept exploding on cross-examination. Karen's attorney, Alan Jackson, is brilliant at cross-examination, and he cross-examined the witnesses to suggest that they were hiding things from the jury, from the public, and that they could be covering up the murder of John O'Keefe by someone inside the home of Brian Albert. Not Karen Read, not Karen Read's car, but someone inside that home. So this is just a little clip from the closing argument, but I want you to just kind of picture the trial if arguments like this did not come in at the second trial, because that's what the prosecution is asking for in this motion.
But for her, the flirtation had ran its course. His text message.
To clear, he's talking about Brian Higgins. Let me back it up. I think okay. All right. So he's talking about Brian Higgins, one of the potential third-party culprits that the defense wants to talk about.
Higgins was clearly pining over Karen, but for her, the flirtation had ran its course. His text message. Well, meaning, what the hell, Karen? What about me? Seemed aggressive, seemed annoyed. He didn't like being ignored. That was pretty clear. So he's 5 or 6 whiskeys deep into the night by this time, and she continued to ignore him. Then oddly, Higgins, who doesn't know John all that well, seems to want to coax John to 34 Fairview. I draw your attention to the waterfall tape if you want to take another look at it. It's at the 11:57 mark. Between 11:57 and 11:58. Take a look at that tape. He's just about to leave. Higgins is just about to leave. He points over at John and he motions for him. Come on, come with me. And then at 12:20, he texts him, you coming here? This is a person he doesn't really know and didn't really talk to that entire night. Ask yourself, why was Higgins so insistent that John go to 34 Fairview that night? And then there's that sparring and fighting that he and Brian Albert were engaged in. And every single witness agreed that at some point, Brian Higgins and Brian Albert left the group and went to another room. Where did they go? Where did they go together? Another important point. Chloe was not upstairs. Brian Albert slipped in one of his testimony that he provided. Quote, "I was watching Chloe downstairs, monitoring her because of the other people in the house. She's not good with strangers."
It diverts jurors' attention away from the defendant on trial.
Let me stop it right there. And I'll go ahead and get it set up for just a minute from now. Okay. So, here's essentially, and that argument was very powerful. The arguments made throughout the trial, the cross-examination of the witnesses about potential bias, of reasons they might have to want to do John O'Keefe harm or to frame Karen Read, any of those things, to not investigate, to protect certain people. All of those things were really important at the first trial, and many of those would not come in if the Commonwealth wins the motion to keep out all third-party culprit evidence. That means evidence that someone, one of these third parties, committed the crime instead of Karen Read, that someone murdered John O'Keefe other than his girlfriend, Karen Read, the defendant. So here's what the prosecutors are saying, and the motion was to keep evidence out about these third-party culprits, and he named 3 specific ones. And he said that for each of these, the defense has offered what they claim to be evidence, but it doesn't really connect any of these people to the murder of John O'Keefe. There's no actual evidence of that. There's no solid reason to believe it, and so you can't let this in. You aren't allowed to do that. Here is Brennan's argument, the Commonwealth's argument, about why Karen Read should not be allowed to use third-party culprit evidence.
Strangers.
Give it just a second.
It diverts jurors' attention away from the defendant on trial and onto the third party. Essentially, it requires the Commonwealth to prove beyond a reasonable doubt the third-party culprit did not commit the crime. If there was evidence of third-party culprit, the defendant should be entitled to use it. In this case, there is not. There is no motive. There is no motive. To suggest that one person was pining, although the text messages don't show that, they both stopped corresponding with each other days before. To suggest that Mr. Albert is friends with Mr. Higgins and therefore he is bootstrapped into a conspiracy to kill with no evidence. Certainly the defense can infer certain facts like getting rid of the SIM card in a way they want, and I don't begrudge that at all. There's different interpretations to it. I understand that. This was heavily considered in the federal investigation, and after that absolute thorough investigation, there were no charges. There was no evidence of third-party culprit. There were no indictments.
Brian. All right, so we'll go ahead and pull that out. The defense named 3 potential suspects, and Brennan for the Commonwealth went into specifics about each one. I'll take you just through a quick tour of what he argued. The first suspect, Colin Albert. Now, John O'Keefe, as I said, was found outside the home of Brian Albert, a Boston police officer, and a number of adults were gathering that night for a party. John O'Keefe was going to go to that party. That's why Karen Read was dropping him off there. But earlier that night, Brian's nephew, Colin Albert, who was, I believe, age 17, had stopped by. He was visiting his cousin. The two sides differ over when exactly Colin Albert left. The Commonwealth says that Colin Albert left before the adult party began, that he was already gone, that he could never cross paths with John O'Keefe. He couldn't conceivably have been the person to have done this. And the Commonwealth says there's just no evidence to suggest that Colin Albert did anything to John O'Keefe. The defense, Karen Read, says, well, there were some things that happened, like a feud with John O'Keefe in the weeks or the months before he died. And the Commonwealth says, there's just nothing to back that up. You don't have any text messages or a witness to testify to that. All you have is the attorneys arguing about it. You don't have anybody coming to say that actually occurred. And that would be a problem. If they don't have any witnesses or testimony, that would be a problem. So there were other claims like that Colin threw beer cans into John O'Keefe's bushes, that O'Keefe cursed at him, that he turned Colin in for drug activity. But the Commonwealth says all of this is just made up. There's no witness who's going to come in and say that this occurred. The only actual documented incident the Commonwealth said today, Brennan did, was a situation where John O'Keefe yelled at Colin Albert's younger brother and then later apologized by giving him candy. So the prosecution says, well, that is hardly a motive for murder. And at the first trial, the defense put in two really powerful pieces of evidence with Colin Albert. One was a social media video clip where Colin Albert appears to be threatening someone, but it wasn't John O'Keefe, and just it was a very short thing. And then there was a photograph that showed Colin Albert with scraped up knuckles. And the argument made by the defense during the trial was that this shows Colin Albert is just kind of a violent guy, and the fact that he had scraped knuckles could have been left over from a couple of weeks before when Colin Albert attacked John O'Keefe. And this could be evidence of that. So in short, and the defense says these are proof, and the Commonwealth says those aren't proof at all. And Colin Albert cannot be seen as a serious suspect. Now, and I do think it's true that just the threatening message, which had nothing to do with John O'Keefe, that may not come in evidence this time around. It'll depend on kind of how things unfold at trial. Now, the possible suspect number 2 named by the defense is Brian Albert. He is the person who owned the home where John O'Keefe's body was found out in the front lawn. The Commonwealth said all the defense has on Brian Albert is just an assault on his general character or just completely irrelevant. Like, for example, claiming he had a bad reputation with other police officers. That has nothing to do with the murder of John O'Keefe, or suggesting he was drinking heavily that day. That doesn't mean he murdered anybody. Pointing out he had self-defense training as a police officer, or saying he was investigated for violent conduct. And the Commonwealth did add that at that point, none of the investigations resulted in any kind of findings being sustained against him. So they're saying, look, all of this is either just really general, like he knows how to box, or it's just not connected. There's not the evidence to put these two together. And that character evidence isn't relevant unless it's connected into the case, unless you have a reason to put the two together. And for that matter, there's really not any proof that John O'Keefe entered the Albert home. This is the Commonwealth argument, because the phone data says he never left the front yard. And while that's kind of true, there is another point there, which is there was some indication that he went up steps. And so the Commonwealth didn't mention that. The third point was that finally there was a third possible suspect, Brian Higgins, who had had a relationship with Karen Reed. And the defense suggested that he was upset that Karen Reed wasn't with him, that she had rejected him and stayed with her boyfriend, John O'Keefe. And he had a beef with John O'Keefe because he wanted him out of the way so he could have Karen. Now, Higgins was at the Albert home that night, but the Commonwealth said, yeah, but John O'Keefe never went in. So the two of them never had any connection. And the fact that he had a flirtation with Karen Reed, that's not a motive to murder her boyfriend. And in fact, we saw kind messages that he sent to John O'Keefe. So what if he went back to the police station? And let me rephrase that. So that one of the arguments that the defense made was that he went to the police station after the party to tie up a few loose ends. And the defense said what he was really doing was monitoring what was happening, what kind of investigation was going on. And there is now video evidence that he was actually talking on the phone while he was there. But the Commonwealth is, what's the big deal about he worked there? So what if he went into work to move some cars around because the snowstorm was coming in? Why do we care? How does that mean he murdered John O'Keefe? And they're saying when it comes to Karen's right under a Massachusetts statute, actually it's a rule of evidence, but there was originally a case, Bowden, and then it is now a rule of evidence in Massachusetts. But under this rule, and I'll go ahead and add it to the screen just a second. That'll take a minute. I have to remove what else do I have? I don't know I have to remove that. Okay, there we go. All right, so Massachusetts Rule of Evidence 1107. It talks about the ability of a defendant to tell the jury and to provide evidence that the police just really didn't try all that hard or didn't do an adequate investigation. Here's what it says, specific to her case. Evidence that certain information known to the police about another suspect was not investigated in circumstances in which it was reasonable to expect that the police should have investigated such information is admissible. So, and the defense is saying, look, they absolutely should have known that these other people were potential suspects, the people inside the house while a body is lying on their front yard. How could they not have investigated that? And essentially, Karen Reed does have a right to talk about the liability and, well, not the liability, the failures of investigation done by the police. She does have a right to talk about that. And the Commonwealth will admit that much. The Commonwealth will admit, yeah, she's allowed to do that. But they're saying there was absolutely no reason why the Commonwealth would suspect that these people were potential third parties. All the police knew was Karen Reed, according to witnesses, was running around screaming about how she hit him. The car she was driving had a broken tail light, and the phone data suggests he never left the lawn. So it didn't occur to anybody that there was this weird, wacky third-party defense that was going to be mounted by Karen Reed. Now, the defense says, nonsense. It's quite clear that the people who own the home, when a dead body is found on the yard, if it were anyone other than a Boston police officer, you bet they would have investigated the people inside the home. They wouldn't have missed that really important part. And so I think it's probably pretty likely that at least under Bowden, some of this information will come in. That's different, though, from saying that there's a third-party culprit. That's just saying the police didn't do a good job figuring out whether someone could have been a third-party culprit. So the defense made a few arguments with Brian Albert. They said, look, this is a violent guy. He was a boxer. He sucker punched another police officer. He was liquored up that night, is how Yanetti put it. He gave their family dog away after 7 years to someone in another state, only after the defense alleged that the dog might have been involved. They said that's clearly suspicious. And both he and Brian Higgins, the one who had the slight relationship with Karen Reed, that they were unaccounted for while John O'Keefe was supposedly in the home. So the police report even listed him as B. Albert instead of his full name, put the incorrect address. They say this is just a cover-up by the Massachusetts police. Brian Higgins was liquored up that night, use the phrase again, and was he had to watch Karen Reed be affectionate with her boyfriend, John O'Keefe. He had this relationship with her, and so he actually was at the Albert home. He was waiting for John O'Keefe. He had motive, he had opportunity, and he said he made no phone calls while he was at the station. I assume that's what they referred to in the closing argument today. I don't remember that point, but that Higgins lied about that because now there's proof that he actually was making a phone call from the police station. Most of all, or at least in heavy part, they also argued that there was a consciousness of guilt because of the fact that he destroyed the SIM card from his phone. And it demonstrates, Yanetti argued, how badly he wanted to get rid of that phone and make sure no one saw that. So when the feds were looking for it, when it became clear he was going to have to turn over his phone, he broke his SIM card in two. He went to a military base, went through security, to put a tiny SIM card broken in half into a gigantic large dumpster. And they said he wanted to make sure nobody knew what was on his phone. And for that matter, it was also the case that Brian Albert destroyed his phone and didn't turn over information. Now, Colin Albert, they said we can prove he had a feud with John O'Keefe, so I assume they'll bring evidence of that at trial. He had the scraped up knuckles. He was completely omitted from police reports until we brought him up. All three of them were right there, the defense says, at the time the murder was committed. And they said if you were to look at it from a different point of view, it would even be ineffective assistance of counsel if we didn't bring this up as a third-party culprit defense. then she would be able to argue we were so bad at trial that we didn't bring this up, because that's how clear it is that these people might have murdered John O'Keefe, and at least it should be considered. I thought this was pretty funny. The defense lawyer Yanetti said, they've spent weeks trying to keep our evidence out. Brennan, talking about Brennan, the Commonwealth attorney, he's acting more like a defense attorney than a prosecutor. And it is the case that normally the way things work is the prosecution is trying to get the evidence in and the defense is trying to keep various pieces of it out. But it's the other way around in this case. Brennan is really trying hard to try a completely different case. He said they can't prove that O'Keefe went in the house. There's no basis to believe any of these people had anything to do with John O'Keefe's death. So it was quite a day. The first ruling, I think Judge Cannone gave them a really favorable ruling that she did not have to do. We don't know yet what she's going to say about the second one. So we'll take some questions now. Let me say thank you to some more people in the chat, and then I will head over there. If you have a question, would you please put question marks at the beginning? It'll be a lot easier for me to spot if you have your question marks at the beginning. Okay, so where was I? I was with Lynette. Thank you for the super sticker, Lynette. Lita asking about, is it possible that Alessi was hired specifically for all the pretrial motions due to his expertise citing cases? 100%. That is exactly why he was hired. Now, I don't know for sure if he was maybe hired for the appeal or what. He's certainly being assigned the heaviest lifting for these motions. Very wise move on lots of levels. One is he's extremely thorough, very prepared, very detailed. There's no question about it. He is a moving force when it comes to these motions. Also, he didn't have the history with the judge that the other three lawyers did. They don't necessarily get along, but Alessi had less of that. So it was just a great move to put him in for that. Very, very well done. Callie, thank you so much for the super sticker. I really appreciate that very much. Thank you for watching tonight. And Dolly, thank you for the recap. It was a wild day. It was really interesting. My favorite part was when she's like, stopped Alessi. I thought that was hilarious. All right, so let's head over and see what some of your questions are. Carol Sue Scott, do you think Karen would have fared better if she did not give interviews? Oh, so hard. That is such a good question, Carol Sue. Okay, I've been talking about how I'm going to teach a law school class on this because this is so critically important, and lawyers don't know what they're doing. That includes me. I may know more about it, maybe having watched some of this, but there is not a great answer here because I am thoroughly convinced that if Karen Read had not taken her case to the public, she would be in prison for life right now, or at least for some very, very long period of time. 100% she would have been. And it was the fact that she went to the public, that a stir was created, that people watched over this, that people were looking at whether or not she was receiving a fair trial, whether or not there was corruption within the police. All of that, I think, is what enabled her to get through the first stage and now onto a second trial or retrial. But huge bite. Anytime a client is out talking, it's dangerous, super dangerous, because you don't know what exactly they're going to say. And if they say the wrong thing, it is terrifying. And in this case, when you talk to a bunch of media for long periods of time over the course of many days, you are going to say some things that are wrong. And that's happened here. So it's the kind of the perfect test case. I think maybe one of the things we're learning is this: there needs to be communication with the public, but maybe it needs to be through the attorneys, maybe less through the client. She's unusually skilled and capable at this. So I understand why they did it and why she thought it was important. I don't know that there's a clear answer, but boy, is it an important question, Carol Sue. Sherry wanting to know, who do you think has a stronger argument? If you're talking about the case overall, I'm going to wait. I'm going to hear everything that comes into trial to try to be absolutely as neutral as possible. one of the things that we see with this case is that people, because we've been through a trial, people have strong opinions about this case. I want to make this channel and this place somewhere you can talk about the case on a sophisticated level with knowing what the facts are, what's happened in the case, and have an intelligent, reasoned discussion about it, as opposed to just picking one side and going all the way down on that. That's what I think that's how we're going to handle it. So thanks for your question. Angel, do you have a theory on why Mr. Higgins wanted OJO to come to Fairview? And I think that would be John O'Keefe. So I think it depends on whether you believe the defense or not. I think the Commonwealth would say he was a nice guy just trying to get along, or maybe he just wanted to see if Karen Reed would come too, and maybe they could hang out and rekindle things. Now, I think the defense would say it's because he wanted to lure him there so that he could be murdered. That's what the defense is going to suggest if the judge lets them. Sad Girl asking guilt or innocence. I'm not going to answer this, but this is interesting. Why do you think she has so many fans? I think a lot of it has to do with people believing, being willing to accept the idea that it's possible that the police were corrupt, and they really want a fair trial for her. I think we naturally want justice, and I think that's one of the things that people want for Karen Reed, for everybody. But in this particular case, there's concern that she's not getting it. I think her ability to talk to the public too, as like a real person, I think that's been really helpful and has shown the public she's a real person. This is how she's really feeling. I think that's been helpful to her in terms of the perception. Victory is asking a great question. Will Proctor be involved in this trial? Lots of us wondering that. I don't see how he could not be. I think he will be. For those of you who don't know, Proctor, the lead investigator, was fired, and specifically fired for things he did in this particular case. And so that's going to play huge at trial. Now, the defense has talked about bringing him, but it's going to change the rules as to how they examine him, so that it may not advantage them if the Commonwealth doesn't bring him, and maybe they won't. We will find out. Mudbath asking, do you think Commonwealth was advised before Proctor was fired that Brennan dismissed the inverted photographs and written them? I'm not sure if I totally understood that. Let me read it again. Do you think Commonwealth was advised before Proctor was fired that Brennan dismissed the inverted photographs and written them? I'm sorry, Mudbath, I just didn't quite follow that. And if you could maybe rephrase, that'll help me figure it out. I'm sorry about that. Sometimes when you're reading things really fast and trying to think on the spur of the moment, it can be kind of hard to do. So sorry about that, Mudbath. I'll try again. Okay, so SG Blues, do you think she did Netflix for the money to pay the lawyers? I don't know. Did she get paid by Netflix? I don't know how much she got paid, if anything, so I can't really answer that. But it's really an interesting question you raise about needing to pay her lawyers, because this is phenomenally expensive. I know her father was helping her, but no one's money is endless. So barring them being billionaires, which they're not, obviously it's going to create a problem at some point, and it is super expensive, and not just one trial, but now two. So the expenses are, if not totally doubled, at least increased by a lot. And they've got to try a different case. They cannot try the exact same case. If nothing else, Brennan is making sure everybody knows that it's going to be a different case, and it really will be. It will not be the same case. Everybody's got to do things differently this time around. RN2 moms, are all the last minute motions normal, or is it an abuse of the system? Oh, it's 100% normal. Now, particular motions that were filed, some of them are kind of late, but it is very normal for lawyers to file a flurry of motions at the end when the last minute preparations sort of hit them. And truthfully, what happens is that lawyers, maybe they haven't fully prepared, and then they start to prepare and they think, oh, wow, I should have moved this. I should have said that. I should have, and then they start filing those motions because now they're fully focused on the case and these things are occurring to them. So the general idea that there's a big flurry of motions at the end, that part's pretty common. Now, the defense seems to think that some of these should have been filed earlier, and that may be the case. But in general, the answer to the question is, yeah, lawyers file a lot of motions right there at the end. Do you think trial should have been moved out of that area? DM3454 asked. If they wanted that, I think it probably, I think they would have a good argument for it. I'm not really sure what request was made on that. I don't know if they wanted that or maybe both sides didn't want that. Sherry wants to know, if you were the police, would you be that amateur in leaving him out to die when you don't know if he would indeed die? Big risk. So I think Sherry is suggesting that the people inside the home maybe wouldn't have been so crazy as to leave John O'Keefe in their front yard. And that was an argument the Commonwealth made last time, that if for police officers, it was a poorly executed murder, if that's what it was. And that's one of the arguments that they made. D asks, what do you think about the fact that Turtle Boy released Hank Brennan's home address and personal phone numbers to the public? I don't think that ought to be being done. I think that's inappropriate. But having said that, I have no idea that Turtle Boy did that or not. I'm just responding in general. Is it a good idea to release home addresses and personal phone numbers of attorneys? No, I don't think so. I think we want to encourage people to work as hard as they can for their two sides. That's how we think the justice system works. But I have no idea what Turtle Boy did, so I can't really answer that question. Would be the better way to answer that. Sassy, I wonder if John went inside and there was an argument. Oh, I don't really think that's a question. I think that I'm getting a bunch of non-questions here. So I think what we're going to do, we will be live again tomorrow night. I don't know exactly what case we'll be covering. It'll be 7 p.m. Eastern. We go live Monday, Wednesday, and Friday, 7 p.m. Eastern. When the trial starts, of course, we'll go live every night. But I want to say a special thank you to one of our moderators. Denise Pelton is retiring from us. She's still going to be coming. She is greatly beloved, and we will miss her immensely, but she has done us such a service. She really has. She has come in. She came in the middle of Delphi, which was definitely jumping into the frying pan. And I am so appreciative to her and so grateful for what she's done to help us throughout the period of time that she's worked with the channel. And thank you so much, Denise. She's still, she's not leaving. She's not going anywhere. She's got some special projects that we're going to be working on, but she is going to retire as a moderator. We are so appreciative of all she's done. Also want to thank our other two mods, Marlon and Mama Pinks. I'm about to play the dad outro that Marlon did. It's a very special outro. My dad did turn 90. We were going to have a very special live stream on Friday, advice from a 90-year-old. What would you ask a 90-year-old? And y'all came up with great questions for me, but Dad ended up being under the weather. So don't worry, it's still coming. But I thought you would just so enjoy this outro that Marlon did. It sort of illustrates what he's seen over the course of 90 years, and it's pretty awesome.